Welcome back to the Legal Smith Unleashed. My name is Attorney Kurt Smith, and I am here talking about different legal issues, family law issues, things of that nature. And wanted to talk today a little bit. Actually, we've been talking about a lot of different topics over the past few weeks, but today I wanted to go to the mailbag. Every now and again I get, well, not every now and again, almost all day, every day, I get questions from people that are looking for legal advice. Some of them need attorneys. Some of them just want the advice, and then maybe they'll need an attorney later. But we'll go through some of those questions right now and see what we can do. And as always, prior to being able to answer any of those questions, I will need my handy-dandy Benjamin Franklin glasses. So, first question, Dear Legal Smith, can I move to another state when I'm 18 and not be forced back? Okay. Look, the question begs a couple questions for me. In Nevada, the age of 18 is the age of majority. So once you're 18, you're an adult and you can kind of do what you want. Now, there's kind of a gray area in some people's minds because the law requires custody orders and child support orders and health orders for parents to go until a child is either 18 or graduates from high school, or 19 if they're still in high school. So in this particular situation, but the reality is that once you're 18 in the state of Nevada, you're 18 and you are an adult. You can go wherever it is you want to go, unless there's something going on with you. For example, if you're under some kind of medical watch or healthcare watch or under a guardianship. Okay. Now, this is a very interesting question because if you're in some kind of a home where you can't leave, going from 17 to 18 isn't going to help very much. You may be under medical care, and I don't mean to imply that you can kind of just do whatever you want, because the doctors may have you where you need to be. But let's assume you're under a guardianship. And I'm going to give the worst advice in the world, but I'm going to do it anyway. So your parents have a guardianship over you. Once you turn 18, that guardianship is ineffective and you can go wherever you want. Now, again, that might not be the best idea. And it actually reminds me of a case that we had a few years back, which is I had a father who needed not only a guardianship for his child, but the child was institutionalized, and so he needed to get this guardianship. And so we helped him file for a guardianship, and one of the problems that he had was that the child was living in a group home, and he wasn't obeying the rules. Rules being you've got to shower every day. You've got to be clean. You've got to not, smell. Was really one of the issues that we had. And you've got to take your medications. And so the father had this child in a group home, and when we do a guardianship here in the state of Nevada, the state will appoint the future protected person or ward an attorney. Now, sometimes that's a good idea, sometimes that's a bad idea, and I can tell you some real great horror stories about when it's a good idea and when it's a bad idea. But in this particular situation, this was an adult child. Dad needed the guardianship. He filed for that. The state appointed him an attorney. And the child started asking questions to his attorney like, hey, do I have to shower every day? Do I have to take my medication if I don't want to? And the attorney, who's still somebody I work with today, in all of his boneheadedness, told the kid, no, if you don't want to do that, you don't have to do that. You're your own person. You have bodily autonomy. Nobody can make you shower. Nobody can make you take your medication if you don't want to. Nobody can make you go to bed at a certain time. That's the advice that this bonehead attorney was giving this mentally challenged child/adult. And while everything that he said was true, the problem with the advice is this kid was at a facility, kind of a group facility where there were other people that lived there. And while certainly he didn't have to shower every day, and certainly he didn't have to take his medication, certainly he didn't have to follow the rules if he wanted to, if he didn't, he's going to be thrown out. And the father was in a position where he couldn't handle the child anymore. And so he's getting this information from his attorney that says, no, you don't have to do that. But the reality is, if he doesn't do it, he's going to have no place to live. So that's not the advice that this bonehead attorney gave him, the bonehead attorney. And so I went to him after this hearing, and I'm like, why on earth would you tell this kid that he doesn't have to follow the rules, that he doesn't have to shower, that he doesn't have to take his medication? And he's like, hey, well, I'm his attorney. I'm just telling him the law. And I'm like, yeah, but you're supposed to be helping him as well. Okay? And when you tell somebody who doesn't have the mental capacity to understand that not doing these things is going to be forcing him to live on the street, are you really helping or are you hurting? And this guy got really upset with me. And I ended up going back in front of the judge and saying, look, I've got a real problem here because you appointed this attorney who is essentially a numbskull and who's giving his client true legal advice that's going to hurt him. So what can we do? And the judge said, look, here's what we can do. If that's the way you really feel, and that's the way I felt, and that's the way the kid's father felt, I appointed the child an attorney. He's going to have an attorney. But you don't have to have a state attorney. You can get your own attorney for the child. And the light went off in Dad's head because he had the money. He just didn't have the ability to care for this child. He traveled for work, and he needed to be other places, and Mom wasn't available. And so we ended up firing the free attorney that was given to him by the state, and the dad ended up hiring an attorney for this kid so that he wouldn't get idiotic legal advice that was actually going to cause him to be homeless. So so for your question, can you leave the state at age 18 and not be forced back? I'm assuming that you're in some kind of a position where somebody can force you back. And if that's the case, you might want to talk to your attorney or your parents or whatever about that. But the reality is, once you turn 18, pew, you're gone. You don't have to stick around. And unless and until whoever's got a guardianship over you files for an adult guardianship, you're on your own. So congratulations. So that's question number one. Let's see. Okay. Dear Legal Smith, I have been experiencing a betrayal in marriage. We have 3 children, 8, 10, and 15. To protect my well-being during this difficult time, the father is willing to walk away and give up his portion of the house. He is not willing to give up the affair. I had someone help draft a postnuptial agreement, but Dad took it to 3 lawyers, and none of them wanted to sign for him and stated that the deal is unfair to him. Should I draft a legal separation instead to be sure it can be used in court in case we need to divorce? I don't want to rush divorce, although it's very painful. I still hope that he will return. What can I do if I continue to hold on the postnup? Anything else that I have to get from him to make sure this agreement is valid in future court? At the same time, I do need to protect myself because he is discussing with a fair partner to purchase a place, and I'm a bit worried. Could you please advise? Many thanks in advance. Okay, look, here's the deal. We have a window, and it depends on the relationship. And look, there's a lot of people that find themselves in this situation where they're in a long-term relationship, long-term marriage, and the partner goes out, steps out, and creates a new relationship outside the marriage, and gets discovered, and has that decision to make. Do I want to break it off with the new person and go back to my family, or do I want to stay with the new person? It reminds me of the CEO and COO that we just saw at the Coldplay concert, right? This guy's got a decision to make. Do I stay with the new girl who I got caught on camera with and the entire world now knows I'm cheating on my wife, or do I go back to my family and try and make things work? Now, there are a lot of people that will go, oh, you know what, I made a mistake, and they go back to their family. And fantastic. If you are one of those families that happened to, and you're the person that got cheated on, and you can get over it and forgive the other person and allow that to happen and resume your life, more power to you, right? But there are a good chunk of guys or people, right, that say, you know what, I was cheating and I feel horrible because we had a great marriage and I've got these 6 wonderful kids and everything is pretty good, but I stepped out and I just didn't know what I was missing, and now I've got this even better relationship and I'm not willing to give it up. Okay? Those people, there is a window, and I can't tell you how long the window is going to be. It could be a week, it could be a month, it could be 6 months, it could be 2 years, right? But there is a window where they feel so incredibly bad that they are willing to sign anything to allow their former partner to move on and not be as hurt as they know that they are, while allowing themselves to pursue the new relationship. That appears to be the window that you're in right now, okay? You have apparently created a do-it-yourself post-nuptial agreement, which essentially grants yourself everything and really kind of does your ex a disservice, or your current spouse that you don't want to let go of. It does him a disservice, and he's willing to sign it. But he can't find an attorney that'll sign off for him because the deal that you made is apparently so horrific that they think it's patently unfair. Look, you don't need an attorney to do this, okay? You guys can do this yourselves, but certainly it would be helpful to have an attorney, because if you've created this patently unfair agreement, you want it not only to be signed by him, you want it to be enforceable once he comes to his senses after that window of opportunity shuts and he goes, boy, I am still happier with this new relationship, and I don't really care so much what happens to the ex and the kids and the dog and everything else over there. And they're no longer willing to sign that kind of a deal. So you've got to act while the getting's good, as the phrase goes. And so what I would recommend highly is to do with him an uncontested legal separation, and get that in front of an attorney that you both use together. There are attorneys that do that. In fact, Smith Legal Group does that. So and get that signed in such a way where once he comes to his senses and says, you know what, not only am I no longer sorry that I did what I did, but I'm never coming back and you realize he's never coming back. And by that time, you've got the house, you've got the pension, you've got $3,000 a month in child support, you got $10,000 a month in alimony, and now he's at the poorhouse because he can't afford all that. But he signed it, and he's got to do it. Ha ha. So there we go. So that's really the bottom line with those types of situations. If you find yourself in that situation, get something signed as quickly as possible. It reminds me of a movie I once saw. I believe I'm on the right movie. Period piece. Nicholas Nickleby. I don't know if any of you have ever seen Nicholas Nickleby, but there was a really funny situation in Nicholas Nickleby, old 18th, 17th century England, and the father died and left the inheritance, as was the tradition, to the oldest son. And the father wanted to make sure that the oldest son took care of his mom and his sisters who needed a place to stay. And so his plan is, I'm going to, give them whatever it is back in the day, right? £1,000 a month for their support, which back in the 1700s was a king's ransom, right? So he's going back to his hometown to get the inheritance, and with him he's bringing his delightfully beautiful bride, who's talking to him about the situation the entire time. And she says, so what is your plan? And he says, well, I'm going to take care of them. I'm going to give them £1,000 a month and let them live on the family estate, and they'll be fine the rest of their days, and we'll be fine with the rest of the inheritance. And the wife looks at him and goes, oh, £1,000, that seems quite steep. He's like, oh, well, what did you have in mind? Oh, something more appropriate. He's like, well, okay, well, we'll do 900. And she still is up in arms because that's 900 pounds that she doesn't have. And by the time they get to the town, she's convinced her husband that they don't need any money, and why can't they just work as servants to the people that we're going to sell the family estate to. That was a very short window in that particular relationship. Get it in writing, get it quickly, make sure that it is done in such a way that it's enforceable. That would be the recommendation. So hopefully that answers your question, and let's move on to the next one. Dear Legalsmith, my divorce order was filed in 2016. The non-custodial parent was to pay child support plus half of the expenses like childcare, sports fees. The non-custodial parent has refused to pay for half of anything. My child has not seen her father for 4 years due to him being verbally abusive. She is now 16 years old and decided to give him another chance. I recently spoke with the non-custodial parent, and he again refuses to pay. I sat down and looked at my taxes as to what I have paid. He owes me about $20,000. He recently again refused to pay and threatens to take me to court for 50-50 custody if I take him to court for child expenses. My child is a teenager now. She likes how visitation is now. I'm worried about having her have to go to court if he does try to get 50-50. What's the advice? I would like to file now, but I could also wait until she turns 18. But would I still be able to file contempt if she's an adult? Could I also request that he pay court costs since he's been uncooperative? Thanks in advance. All right, look, a lot of questions in that big question, but here's the deal. When you have a court order, that's enforceable. It's enforceable until it's not. Now, when we have children involved, it's enforceable usually in a lot of circumstances until the child is 18. So you've got a 16-year-old child now. Now's the time to do it. Now, you've said the magic words, which is the child is 16 and has lived with you forever. If dad does take you back to court for 50-50, the worst thing that's going to happen is his child support is going to be lowered, or I guess it could be even worse. Maybe you have to end up paying child support. But I'll tell you how that's going to work. Your child support would be taken off of whatever arrears he owes. You've only got about 2 more years, and I doubt you're going to make up that $20,000. And you say $20,000, I say $20,000 plus interest, which has been compounding over the past few years. So since 2016. So you're looking now at what, 9 years of interest on that. You're not owed $20,000. You're owed about $60,000. And so by the time he gets you back to court, yes, that's going to be ordered. He may take you for 50-50, but you're going to be able to hold him in contempt of court. Now, contempt is a fun thing, but with an order of contempt, you are entitled to either sanctions, which in this case would be a $500 sanction, up to a $500 sanction per act of contempt. Now, if Dad hasn't paid his about $20,000 worth of fees that he's been owing for the past few years, every time he didn't pay when he was supposed to is an act of contempt. So if there was 60 of them over the past few years, 500 times 60, that's about $30,000. So we get another $30,000 on top of that if the judge really wants to be vicious. We can jail Dad for up to 25 days per act of contempt. Now, usually the judges in these contempt situations will save that as a last resort. But again, if there's 60 of these missed opportunities, 60 times 25, Dad may end up spending quite a long time in jail if you get a really mean judge who wants to enforce that. And judge would be perfectly within their rights to enforce that. Or the Dad can be sanctioned in some way. So the way that he would be sanctioned would be typically monetarily through the payment of your attorney fees. Now, then there's the question, well, could he really wrestle 50-50 custody away from me? It's possible, but we've got a legal concept here called unclean hands, okay? And the unclean hands doctrine goes something like this. Do not come to court. When you come to court for a legal issue where it is what you're asking for is inequitable, okay, based on a bad act that you yourself have done, you're coming to court with unclean hands, and the court has no duty to give you the relief that you're looking for. So while it's possible that Dad may end up getting that Dad could end up getting more time than he has, the reality in this case is because you're taking him to court with unclean hands, the judge is likely to give you what you want and not give him what he wants. Number two, again, I've said this before on the show, but I'll say it again. Timing is everything in a family court case, okay? If you've really got this issue where Dad owes you $20,000 plus interest, and you're the one that files for contempt to try and get the money back, then what the court is going to look at when Dad files his counter motion for modification of custody to primary or joint physical custody from primary custody, the court is going to look at what Dad's doing as retaliatory, okay? So he's going to come in and he has to give the court a reason, and he's certainly not going to say, look, I would have let sleeping dogs lie, but because Mom's coming after me for this $20,000 plus interest, I'm going to come for custody. And the court's going to say, you know what, wow, you are kind of a schmo because you didn't really want custody. You're just trying to get custody to punish Mom. And what you have to show before we change custody is that, number one, there's been a substantial change of circumstances, and a valid substantial change of circumstances does not include Mom taking you to court because you're $20,000 plus interest in arrears on your payment of these medical and sports fees. And number two, you've got to show that it's in the child's best interest. But I don't even have to look at the child's best interest, says the judge, if you haven't showed me that you've got a valid reason to change. And the only reason I can see is you're trying to get revenge on Mom for trying to enforce the court order that I made several years ago back in 2016, or another judge that's just like me. And so, no, I am going to grant Mom what she wants. The monies that she's looking for plus interest, I am going to give her some sanctions, and you are going to pay her attorney fees, and we are going to probably set up a payment system for that to happen. And by the way, your relief is denied. So, Mom, if that's the case, you are in really good shape, give the office a call. We'd be happy to help you out with that and ensure that you are getting everything that you agreed to or you were ordered to get back in 2016. I got time for another one. The ex has 90 days in jail or to purge, pay $400. This isn't really a family law question, but we'll take it anyway. It says X, right? That must mean it's a family law question. The ex has 90 days in jail or to purge, pay $400. She is past due. See, sometimes it's the moms that don't pay. She is past due from July 1st due date, and I filed a motion for commitment and the papers for a warrant with the court, and it is with the judge. If she pays the money before the warrant goes into the system, do I just write the court a letter and let them know she paid, not sure the process, or does she have to let the court know that she paid? Okay, look, this is again kind of a contempt issue, but with contempt, contempt is the non-following of a valid legal court order, but with any act of contempt, there is the ability to cure. Okay, so a cure of contempt means, for example, in this situation, you were supposed to pay $400 and you didn't. Now that you've been served with papers to come to court, you cure that, you pay the $400, and now there's no contempt. Okay, and so that pay, or what they call that, purge pay, would be purged at that point, and there's a couple different options for you. Number one, you can do nothing and simply appear at the courthouse and let the court know at that time. You can do, which is fine. You can do nothing and nobody shows up and the court's just going to dismiss the case. Number three, you can, well, in this jurisdiction at least, we don't write the court letters, so you would file what we would file is a notice of voluntary withdrawal of that motion for order to show cause, or you can do a stipulation in order with the other side and let the court know that you've resolved the issue and there's no more need for the court's involvement. And quite frankly, the court appreciates that when we do that. Last one. My child was taken from me at 2 months old. He's now 2 years old, and I haven't seen him since he was taken. I live in state A and work at a restaurant, and after child support is taken out of my check, I can't pay my bills. I can barely make rent. The father has custody and has a protective order against me, so I'm not even able to contact him or check on my child to speak with him. I would like to terminate my own parental rights. Now, this is a mom that's writing me this question, and Mom, I feel bad for you for what you've got going on, but typically it's the dads that I get this question from for the exact same reasons. Hey, I got a kid out there, I'm not even seeing the kid, so why should I pay for a kid that I don't even see? And here's the answer to the question. May I terminate my own parental rights? No, you may not terminate your own parental rights. And here's the reason, right? Because this happens a lot, and a lot of times the person with the child is a low-income person, and they're applying for state aid like Medicaid or food stamps or WIC or reduced housing. And guess who gets to pay for that? The taxpayers do. The state of Nevada does. Your state, wherever you are, has to pay for that. And they want somebody to go after to be able to recoup the money that they're paying out on behalf of you, which is your child support. So the state's providing aid. They want to be reimbursed. And if they let you terminate your parental rights, they've got nobody to go after. So the answer is the state will not let you terminate your own parental rights. The best thing you can do is contact the opposing party through an attorney, if that's what it takes, and try and do some kind of a stipulation where we either reduce child support in exchange for an agreement not to go after custody, or do something that will allow you to get your child support reduced if you promise to leave everybody alone. That might be your best bet. Otherwise, I'd be going back to court and fighting for custody, because you're on the hook for child support unless the parent with the child gets a new partner, husband, wife, whatever, and they the new partner agrees to adopt the child. In that circumstance, the adoption will go through. Your parental rights will be terminated, and then you don't have to pay child support anymore. So hopefully that helped. We get questions like this all the time, and this is what I spend a lot of my day doing, is answering questions like this for people with legal trouble. If you like the content that you're hearing, please share, like, subscribe, download, forward, and do all those things. That helps us keep bringing content like this, and we will see you next time on The Legal Smith Unleashed.